Hi everyone, welcome to today's webinar on Divorce and You. This webinar is a collaboration between the Law Society Pro Bono Services and the Family Justice Courts. My name is Lian and I will be moderating today's talk. Before we begin, here are some important matters I'd like you to take note of. Relevant materials for today's talk can be downloaded via the QR code, which will be on the slides later during the webinar. A link will also be provided in the follow-up email sent to you tomorrow. Feel free to ask any question during the webinar. You can use the Q&A icon at the bottom of your screen. Your questions will only be seen by the organizer, and we will do our best to address as many as we can. Please note that this discussion and any material provided is not intended to constitute professional legal advice. Please consult a lawyer if you require specific legal advice. Now, before I introduce our panel for today, I would like to poll the audience. This will give the panelists and I an indication of what you most wish to learn today. So if we could bring up the poll, I hope that all of you will participate. We'll do it for about a minute or two. Closing the poll shortly. Maybe that's next. Let's have a look at the poll results. Now it says that majority of you just want to know more about getting a divorce in Singapore, as well as ancillary matters, meaning custody, maintenance, and division of matrimonial assets and stuff. It shows that at the moment, no one is applying for a divorce or expecting, so it's really just a general knowledge. So let's see how we can help you this evening. I'd like to introduce our panel, our very distinguished speakers for today, Miss Susan Tay and Miss Abigail Lee. Hi, Susan and Abigail.
Hi, Lian.
Hi, Lian.
Okay, so our legal expert today is Miss Susan Tay. She is founding director of OTP Law Corporation. In 1991, having worked 2 years as a litigation lawyer, Susan started her own practice, and she focused primarily on family and matrimonial law. She is a parenting coordinator with the Family Justice Courts and also a collaborative family lawyer. Susan, maybe tell us a little bit about yourself.
Well, first, very, very happy to be back, and good evening to everyone. I don't know what more to that quite good intro you have done, Lian. Perhaps just a bit, well, this year I celebrate my 34th year in practice. So in some ways, I have seen the dramatic shift of family law practice from the 90s, when a lot of emphasis is on rights, and you just prepare for the day in court, hearing before the judge, to say 2014, when counseling, mediation were made compulsory for family matters with children. And then today, where the judge is, the family courts are focused on therapeutic justice, which is for the courts to look at cases through a lens of care. So we have a lot to share today, and I really hope that we can help those out there who need some clarity in their decision making. Yeah, that's what I want to say. Thanks.
Yeah, thanks, Susan. Very true. I mean, it's a terrific time. I mean, I think Singapore family courts are really going through a new season, and we are very, very excited to talk about therapeutic justice. And I think you all can see it's all going to be coming out later. I'd like to introduce Abigail. Abigail is founder and executive director of Healing Heart Center. She has over 15 years experience as a professional counselor with a focus on children and adolescents. Abigail is a parenting coordinator with the Family Justice Courts and a collaborative family practice counselor, working with families undergoing separation and divorce. Abigail, tell us a bit about yourself.
Thanks, Lian. Good evening, everybody. Thanks for having me here today. It's quite nice to be involved in a talk like this, where it's predominantly a lot of legality, a lot of legal stuff. But nice to also have counselors and helping professionals on board. So hopefully I'm able to kind of give you a little bit of perspective from that angle. And like Susan said, so much of the direction now is towards therapeutic justice through the lens of care and healing. So it's really something that's very holistic and collaborative. So I think it's very exciting for that. Just a little bit more about myself in addition to what Leanne said. So as a counselor, predominantly I kind of work with individuals, couples, families. I kind of say I work with whoever's a human being, helping them process through negative life experiences. And in addition, I'm also a play therapist supervisor. And what that means is that, like Leanne said, I work a lot with children and adolescents. And for children and adolescents, sometimes it's difficult for them to verbalize or to express what is going on the inside of them, be it feelings or thoughts, and many times what we then experience is a lot of behavioral outbursts. So as a play therapist, I use the child's natural way of communicating it with us, which is really through play, to be able to help them work through some of these negative life challenges that they have.
That's very, very interesting. Yeah, thanks. Okay, so we have quite a lot to cover today. Quite excited to talk about all the new developments. So let's move on. And I just want to give you a roadmap. So we're going to be here for an hour and a half to 2. So this is what we're going to be doing. First of all, the Family Justice Courts has in recent months published some excellent guides regarding divorce law as well as the divorce process in Singapore. You can pick up a hard copy from the court. They are nice, bright yellow. But we will also be providing you with a link to download a copy during the talk. Today, we want to touch on upcoming developments in the Family Justice Courts. You've heard the word therapeutic justice brought up many times. We'll tell you what that's all about. We also want to discuss the basics of divorce law, and I want to try to answer as many of your questions as possible. So let's dive right in, okay? The flow is going to be like this. We will quickly talk about eligibility to apply for divorce in Singapore. And then we'll talk about the ground for divorce. And from there, we move on to the divorce process, during which we will discuss therapeutic justice and what it means. And finally, we will talk about ancillary matters, which majority of you were also very concerned about, your maintenance, division of matrimonial assets, and custody of children issues. So that's what we're going to do. And then we'll close off with a Q&A session. Okay, so first things first, eligibility. Let's deal with whether you are eligible to file for divorce in the Singapore Family Justice Courts. Now, we've seen a rise in international marriages and divorces over the years, right, Susan? And, that means that one spouse is non-resident or neither a Singaporean citizen nor PR. So what are the criteria that must be met before someone can file for divorce in the Singapore Family Justice Court, Susan?
Okay, so a simple answer to that is that you have to fulfill the domicile bar. Okay, you have to be domiciled in Singapore, or you have to be a resident in Singapore at least for 3 years before you file. Now, of course, you also must be married for 3 years. In Singapore, that's the requirement. you must be married for at least 3 years before you can start filing for divorce. Now, I cannot dwell on such technical issues like domicile. I recently did a case and we went all the way up to the High Court for 2 Singapore citizens to prove that they are domiciled in Singapore. Okay, so it's a very technical issue, and I want to stress this, Leanne, when you said that it is on a steady rise, right? International marriages, that's a bit of an understatement. The statistics is 1 in 3 marriages in Singapore actually involves a foreign spouse. 4 in 7 children, yes, have a parent who is not a Singaporean. So this issue could be very relevant to many, many people. My advice to you is seek legal advice if you know all these are important matters to consider before you start divorce. Okay?
Okay. Now, is it true that, okay, so we have the domicile, that means 3-year residency as well as married for 3 years. This one I think doesn't qualify as a criteria, but I believe that as one of the steps that you must take before you can begin your divorce application in Singapore, the courts require that the applicant attends what is called a mandatory parenting program. Is that correct? It's a prerequisite or something?
Correct. So there are also 2 major prerequisites. One is if you have a HDB flat, then of course you need to provide certain information before you get filed, right? The more important one is this program that you have to attend, which I'm sure Abby, you can elaborate later. Is mandatory parenting program. You need to fix a date, and then they give you a certificate before you can file your divorce.
We want to quickly just touch on it, Abigail, then after that we can move on to the ground.
Sure. So basically the mandatory parenting program, or MPP, we call it for short, it's about a 2-hour session and it's run by counselors from the divorce support specialist agencies, what we call the DSSAs, as well as the Strengthening Families program at Family Service Center. So we call it FAM at FSC. So we've got a lot of all these, abbreviations here. And basically what it means is that all parents with children below the age of 21 years old are required, all right, under the Women's Charter to go through this program. It's online and it's a consultation session. And basically it seeks to achieve 4 basic objectives here. So one, the session is basically aimed to help parents understand the financial challenges of divorce, how divorce kind of impact maybe living arrangements moving forward, child custody and access, which is a big issue, as well as the importance of co-parenting and having a parenting plan. So these might be even some considerations that individuals kind of filing for divorce may not have considered. So this 2-hour consultation session or this MPP program really seeks to kind of address that.
Okay. So I noticed actually some questions have come in. These will be dealt with at a slightly later stage, 2 slides from now. So let's quickly deal with the ground for divorce first. So we've established eligibility, which means that you can file an application in the Singapore courts. Now you must satisfy the ground for divorce. So Susan, tell us, what is the ground for divorce in Singapore and how do we prove it?
Okay, so in Singapore, there's really only one ground for divorce, right? You have to prove that your marriage, the technical term is irretrievably broken down, all right? Meaning the marriage cannot be salvaged. How do you prove it? You have 5 facts which can support this ground, right? 1, adultery, but it must be committed by the other spouse. So if you're applying, you cannot be the party committing adultery. Then there's also unreasonable behavior, again, is on the other spouse or of the other spouse, and desertion. So what does desertion means? The other spouse has left the family and have left the family for 2 years. Okay. Now, there's also 2 other grounds, which is less fault-based. It's 3-year separation, but the other party must consent to divorce, and 4-year separation, where you don't need his consent, his or her consent. So this is simply the facts, how to support the irretrievable breakdown of the marriage ground.
Okay, so does it matter which one is used when a person files an application for divorce?
Okay, so you see that of the 5 factors, right? There is some difference, some bit of a difference. As I've mentioned, the 5 facts to support the irretrievable breakdown, you see that the first 3 facts are what I call fault-based, right? So those fault-based reasons, like adultery, you actually can claim not only legal costs, you can also claim your PI costs against the other spouse if you are successful, right, in proving these facts. Likewise, for the fault-based, the other 2 fault-based factors, you can get legal costs. Although this legal cost is not 100% like compensation. The other 2 more neutral grounds, which is 4-year and 3-year separation, then you cannot get legal costs. Okay, so this is the subtle difference. Now, some people may think that, oh, if I use these fault-based factors, maybe I can get more in the ancillary matters, right? Like more maintenance, more division of assets and all that. My simple answer to you is no. It is not correct, because for those issues like maintenance, court, or even division of assets, right? They look at other factors. Maintenance, they look at expenses, needs, income, not how you behave in your marriage or fidelity. In terms of matrimonial assets, courts will look at things like contributions, right? Financially, non-financially, direct, indirect, towards the acquisition of these assets.
Okay, so basically, there is some difference, but it has to do mainly with legal costs.
Yes.
So for parties who, you know, many of us, I think lay people, we have this impression, right, that if I can prove that it's my spouse's fault, then of course I should get more because I'm the victim in this case. But actually, that the court has not approached divorce from that perspective for quite some time, I believe, right?
Yes.
Okay. So now this one would be interesting because I know recent news suggests that the government is considering introducing a no-fault divorce option or amicable divorce. So will anything change for applicants in the near future?
Okay, here I might want to test everybody's patience and then go a bit on that proposed amendments, right? Because it has a lot to do with therapeutic justice. There are 3 main objectives to these amendments. What the courts and the authorities want to do is to provide, number 1, provide couples, children, and also family members with a much better support system before the divorce and then later on after the divorce. Okay, and then they also want to, that's the first one. The second one is to provide an avenue for people who want to get a divorce to not have to make allegations that will put a negative light on the other party, because often this will worsen relationship. And if you have children, it invariably affects co-parenting. Which brings me to the third aim, right? It must, the court will have even broader powers to help parents to co-parent fairly after the divorce. Now, this part, it deals with like programs, co-parenting programs. It deals with enforcement orders or for access and things like that. Now, why do I bring this up? Because it way into this thing you asked about divorce by mutual agreement. Okay, so the new fact to support irretrievable breakdown will be divorce by mutual agreement. So yes, Abby, Lian.
Yes, Abigail, please. Do you have the feedback?
I saw Lian, you wanted to ask a question about divorce by mutual agreement.
Yes, because coincidentally, that was one of the first few questions that we got today. Someone asked, can we file for divorce with mutual consent? Would it expedite the process? What are the advantages and how fast? So, but I believe that, is it fair to say that this new one, divorce by mutual consent, I'm not sure that all the details are out yet as to, you know, is it quicker than the current simplified track, which we will be touching very, very shortly. Yeah, but there is definitely this option that's coming out very soon. Will it be this year?
Okay. It is likely to be this year because the bill has already been passed. Okay. So now we are very early in the year of 2022. So I expect that it should be this year. Okay. Whether it is how fast and how much details I can tell everybody now, If you want to file divorce by mutual agreement, there are still things you have to do. Okay, you have to put in an agreement to state, number one, how the reasons for why the marriage broke down. You have to state all this. And then you have to state the efforts that you have made to try and reconcile. Okay. The third thing that you have to say is the kind of considerations that both of you have already made with respect to arrangements relating to the children and your own financial affairs. So it's almost like you have to also deal with the ancillary matters. Okay. Now, the court may or may not grant you the divorce by mutual agreement. What is interesting for us is that for the first time, right? I mean, Sharia court always has a very different practice, and they also focus on reconciliation, but not the civil court. But for the first time now, they will look at whether, okay, perhaps party, if you can reconcile, then they won't grant you the divorce. And they will make efforts for you to try and reconcile. So I do not know, to be honest, how this is going to be done, because it's not coming into effect yet, right? But I do expect that, because you now don't have to fulfill 3-year separation, 4-year separation, and then you don't have to allege all the fault-based facts, right? Things should get better. You know, if as long as the two of you say, okay, let's divorce, then you don't have to go through all the other, what I would call nasty things. It should be easier, if not faster, than simplified track. I will, of course, talk about simplified track later on.
Okay, yeah. Okay, this is let me very quickly deal, because 2 questions have come up regarding our earlier topic about eligibility. It seems that we have some participants that are quite perturbed by this 3 years separation in order to file. Someone asked, is it an arbitrary number? Sort of why 3 years separation before you can file? In fact, there is also a 4-year separation for filing without consent.
Okay,
right?
I need to talk about eligibility, because I think I didn't say 3-year separation. Eligibility is how can you file for divorce? I think I said 3 years. You must have been married for 3 years at least.
Yes, indeed. Correct. So the 3-year separation, I think, deals with the factor for grounds of divorce. So I think this member of is just curious whether why is it why 3 years you know? And then coincidentally, someone else did ask, is there a reason for the minimum domicile of 3 years as well before people can file for divorce in Singapore? I guess that's just the law lah. I mean, these clauses have been in the Women's Charter, right, for a very, very long time. So
it's the law. It's a legal position in many countries, because otherwise anybody can go anywhere to get a divorce. I get married in Singapore for no rhyme or reason. I suddenly say I feel like going and get a divorce in Thailand. It cannot happen. So likewise, for people who want to get a divorce in Singapore, you can't just be a tourist and come and get a divorce in Singapore. You have to prove that, okay, you're either domiciled in Singapore. And that's why I don't want to explain this whole domicile thing, because as you can see, it's already confusing the audience, right? It's not domicile, it's very different from residence for 3 years. It's 2 totally different concepts. Okay, so I don't want to confuse everybody further, but these are some of, understand that, okay, if you're a tourist, can you come here and get a divorce? No. Why? Because you need to either be domiciled in Singapore, or you need to have been a resident in Singapore for at least 3 years.
Okay, so before we move on, I just want to let participants know I see your questions. Some of them we will be dealing with as the talk goes along, because it's already planned for, and others we will deal with at the appropriate juncture or at the end. So we want to move on so that, you know, we can go with the flow and understand next, which will be the divorce process, right? We've covered the ground for divorce, and then now we want to talk about the first and second stages. Earlier, Susan, we were talking about therapeutic justice, and somebody asked about divorce by mutual agreement. And during that discussion, some of the criteria that had to be satisfied, right, sounds a lot like the simplified track in the divorce process. So maybe let's talk about these 2 paths that parties can take in the divorce process and what the difference is.
Okay. Before I go into this whole divorce simplified track, or maybe even contested, uncontested, right? I just want to briefly touch on how it is done in Singapore, okay? When a client first come and see me, I often tell them, okay, in Singapore, there are 2 stages to divorce proceedings. Number 1, stage 1 is to talk about whether you fulfill the fact, you have the facts or not supporting irretrievable breakdown of the marriage. So stage A talks about whether the marriage has failed or cannot be salvaged, whether a divorce can be granted. That's stage A. Then there's stage B. Stage B deals with ancillary matters, which it will be things like maintenance, division of assets, children. Okay? Now, usually stage A has to finish before they move to stage B, right? Now, both stage A and stage B can either be contested or non-contested. What is contest? Contest means you fight, simply put. The very, very highly contested one, acrimonious one, you fight. Both stage A, stage B also you fight. Okay? Then there is the uncontested, meaning you totally don't fight. Now, uncontested sometimes don't mean that they agree. Sometimes it just means they don't react. You file something, then they totally don't do anything. Okay? But there is, of course, the third one, the most important, the important one, which was mentioned by you, the simplified track, right? Simplified divorce track entails a full agreement of everything in stage A and everything in stage B. And you do that before you even file for divorce. Okay? So this is the track that the courts, even lawyers like us, will want to encourage parties to use, right? Because this kind of divorce will take the shortest time in court and often means that somehow relationship can be preserved. It may not be enhanced, but preserved. Why is this important? It's important for co-parents, right? People who don't have children, maybe they don't really care about preserving anything. But when you have children, the co-parenting never stops, right? So this is the point also I want to say. The name is sometimes deceiving because simplified doesn't mean that it's simple. Because talking about divorce, it's a whole new session by itself, right? Talking about how we do this whole simplified thing. So this is the point where I want to talk about our next seminar. For those of you who will be interested in finding out how to do this, Society Pro Bono office is also going to do one seminar called the pre-divorce workshop. This will happen sometime in April. And this workshop will be conducted by a lawyer and a psychologist. And at this workshop, you can find out, okay, when do you know your marriage is on the rocks? You can learn about how you talk about divorce, which is a very, very difficult topic. How do you talk about divorce to the other party before the writ is even filed? And then there will be a checklist of things you should do, checklist of things you should try and avoid. We will also explain the divorce process, the amicable versus acrimonious, and how the acrimony can affect the parties and can affect children. So this is going to be an interesting workshop for those who want to find out more about how to do this.
Definitely looking forward to that. I think that one, I mean, really just helping people take steps,
Yes.
Yeah, useful steps towards beginning the process far more amicably. And yeah, okay, I think this is a terrific time to talk a little bit more in depth about therapeutic justice. But before we start that, right, Abigail, we've talked about the process, we've talked about the law, but I know you've counseled many couples who've decided that marriage is over, broken down. Sometimes there's one party coming in, sometimes it's both. So tell us, are there any benefits to seeking counseling if they already know they want to get divorced, no plans to reconcile, right? Yeah.
I think, okay, in short, yes, definitely, right, that there are benefits. I think that it might be some misconceptions about what counseling does within this context. And many times it's almost like that idea of, okay, marriage have broken down, divorce, and then that's it. We go our separate ways. Of course, if there are no kids involved, many times, yeah, people go their own separate ways and then they don't necessarily stay in touch. However, if there are those with children, then that's where, you know, a lot more issues kind of come up. And having said that, I'll come to that in a while in terms of like the benefits. And sometimes even as an individual, you know, even though you have decided that, you know, okay, divorce is the only way, I think many times, at least the individuals that I have counseled, they don't realize the impact that it has on them emotionally, mentally, and also in terms of physically, because it's somebody that you have lived with maybe for a couple of years, there's an attachment there, and then suddenly there's no longer this person in your life. You know, so even there are transitions, there are adjustments, there are losses to kind of work through and to process through. You know, there would be different bags of emotions to kind of look through, even as an individual. So some benefits in terms of working through one's own emotional responses, cognitive responses and reaction, both the lows and the highs. You know, people talk about how there are days where I'm so angry with my ex-spouse. And then there are days, oh, but I really miss, but this person was so nasty. You know, so the ups and the highs and the lows, counseling helps you to kind of process through that, to help to regulate that a little bit. The other thing also, sometimes when divorce processes are not in the simplified track, for example, it can be a long drawn process, and the individuals or the couples or the parents that I've kind of worked with, I think they don't recognize that there is an impact on emotional and mental well-being, given that there's this long drawn fatigue that kind of takes place with the proceeding. Because it's not like, okay, I'm having this long drawn battle, I stop my whole entire life, I stop work, I don't do anything else, I just focus on the divorce. You know, if you have kids, your kids still needs to eat, you still need to send your kids to school, you still need to help provide the basic needs of your kids, you still have to go to work, you still have to, you know, earn money and put food on the table. So all these other things are still ongoing as you are undergoing through the battle for the divorce process. So recognizing the impact and the toll that it has, and how do you manage and kind of cope and contain all of that as you are going through, you know, that's another benefit of counseling. Co-parenting issues, always a big one, you know, especially when you are not communicating with your ex-spouse. That's something that can also be worked through either together or separately, individual, right? What happens when your child comes back after having been with the other parent? How do you nurture? How do you support? How do you attend to your child? Right? All these kind of things get talked about and processed through in counseling. And, you know, sometimes people ask me, then like that, I talk to my friends, you know, they also offer me advice, and then they give me some kind of emotional support, and nothing wrong with that. It's good that to have a social support network in place, except that in counseling, many times we become the neutral party where we can provide certain perspective that hopefully can provide some insight, as well as identify certain blind spots that maybe were not considered before. Because I mean, truth be told, right, if you are kind of sharing some of these things with your friends, chances are your friends are on your side, and your friends will kind of align with you about how nasty your ex-spouse is, right, or how nasty the other parent is. So really the goal, in essence, in terms of processing through all this, is really about healing.
And come to think of it, friends sometimes might not be equipped to sort of help you or give you tools as to how to deal with, right? I mean, you know, I mean, we listen to our friends, and then we like hug them. We are like, oh, you know, angry with them. They feel good, but then when they go home, they step into the house. I mean, I'm imagining a situation where the divorce is like maybe ongoing, or marriage on the rocks, but, you know, not sure whether to commence proceedings. They have to interact with the spouse still. And there's nothing very much the friend can do about that. But I imagine a counselor can give you some tools. You know, that's so I can imagine that.
And also, I think customize, you know, something recently that I've been telling all my clients when they first come and see me is that I am not Miss Google, you know, so don't come in and then kind of expecting me to give you kind of like step 1, step 2, because everybody's situation and everybody's circumstances are different. What works for you is not going to work for somebody else. And what you Google, and sometimes when you get contradictory information on Google, and then you start trying things, and then you say, oh, this doesn't work, and then you feel more confused, right?
That's
so
very true.
that's not very helpful and beneficial. So speak to a professional.
Plus, Google's algorithm can send you on the same path, if you started with the wrong question, and then, Google will know
Yes,
what you're seeking for, and then all the answers will come out the same way.
that's right. That's right. Yeah,
I've encountered that, for other issues. Okay, but let's get back to therapeutic justice, right? So, Susan, someone applying to get divorced in Singapore, maybe we don't say today, but, the law is changing. I'm sure we are in the midst of the change. But what will therapeutic justice mean for them? I mean, earlier you said compared to the old days, it was you versus me, and then the court is like the arbiter. So with therapeutic justice, just tell us more about therapeutic justice. How is that going to change the way divorce cases are handled generally? Yeah.
I think the courts, they are going to put in a lot of processes that is going to support this whole notion of lens of care. So if you hear from Abigail, you will hear that counseling does this and that, right? There's a lot of support. There's a lot of understanding and then processing of your emotions, perhaps so that you can be in the right place to make decisions, because every day is going to be about decisions. And so the therapeutic justice is going to be about how people who want to go through divorce can access all this kind of support even before you start the divorce process. Okay, so before you start, you will have information to help you, well, like what Abigail said, help you process and move on and let go. Okay, help you understand the consequences of breakdown of the marriage and the impact that this whole thing will have on your kids. That's pre-divorce application. Now, during the divorce application, usually that it goes back to me saying how in the 90s, right, we were talking about, we go to court, it's about my rights, this is your rights. The court wants to reduce that kind of, our parlance, we say adversary lah, okay? They want to promote both parties as joint problem solvers rather than opposing, right, people. Okay, so that's during the court process. And then after the whole applications, there should also be a system to support not just the post orders, like the legal issues. There will also be non-legal issues they want to help to see, to see whether the family can have access to. Okay, and this is interesting because some of the programs that is suggested will, like I said, include co-parenting, right? Not only that, they might also introduce programs where they will have caregivers like grandparents attend. Okay, they will have children attending programs where it will be about how they cope with the idea of divorce. Many children don't verbalize what they're going through. Okay, so they'll be taught how to speak up, how to understand what their own feelings are, handle their own emotions, things like that. So therapeutic justice is so all-encompassing, not like back in those days before this, where it's about going to court, finish, you get your court order, that's it. Everything over, you got to go and deal with it yourself. Yeah. I hope I answered your question.
Yeah, definitely. So Abigail, right, since counseling is going to play such a big role, maybe just give participants an idea of what marital or family counseling sessions are like. If they walk in, is it many sessions, one session? How does it typically work?
Yeah. Before I kind of go into that, I think just adding on to what Susan shared about TJ, right? In the past, right, when I work with clients, there was and no fault, this is not pointing at you, Susan, right? But I hear so much negativity about, the lawyer, and then my ex-spouse lawyer, and a lot of negativity about lawyer this, lawyer that. And then they are kind of like showing me documents that I absolutely have no idea about because I'm not a lawyer, right? So I'm sitting there feeling really confused, and it's like, okay, who do I talk to? Everything feels very disjointed. And I am personally very excited about, this whole approach of TJ, because it really means that with the different professionals kind of reaching out and helping the same family, it's very holistic. It's all collaborative. We are bringing all these professionals together, and we can at least have some kind of discussions and like understanding about, oh, okay, so that's your role. That's what you're doing. Okay, this is kind of what my role is. And together we are supporting the family. And I think it's really, again, with the whole goal of healing, bringing the family together. So I'm very excited about that, because now it doesn't feel like I'm like, my clients are like breaking down and crying, and then I'm like, okay, I have no idea what you're talking about in terms of the legal sense. I can reach out to Susan and say, hey, what is this? Can you help me to understand this? And it's no longer about just like acrimonious and negativity. It's about problem solving, like what Susan said. Okay, so back to about how does kind of marital, family counseling sessions kind of look like. In short, like different counselors would have been trained in different kinds of counseling approaches. So you might be going to different counselors and they might have different kinds of marriage and family counseling approaches that they have been trained in terms of therapy wise. So that can look a little different from counselor to counselor. But if we look at the session as an overview, generally, there is an identification of the goal. All right. So why are you even asking for counseling? What is the help that is required? So I think another misconception sometimes is that it's a never-ending process, right? It's like, how far back into your childhood do we dig? And then it's like never ending. It just feels like there is a never-ending thing. But really, generally, there's always an identification of the goal. What is it that you're looking at achieving? And then let's kind of ascertain how this issue, how this concern came about. So yes, for some counselors, we might look at things in a family of origin, things in your childhood. We might look at present triggers, etc. And then, okay, how do we work through towards resolution? So it can range. I joke and say that, I always get asked like how many sessions, right? And I always say it depends, because it really depends from individual to individual. Some people require a little bit more longer time because they're more contemplative. They require that space and time in between to go a little bit deeper, whereas others, their way of processing is just boom, 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 right? And then for me, for example, right, as a play therapist, then I kind of include play and expressive arts into the sessions. And it's not just about playing and having fun. The whole idea with these sessions is to facilitate the clients in being able to gain insight and to increase awareness. Right? So it sounds very linear, it sounds very simplistic, but usually not the case. So I always say that in terms of how these sessions go, we think that it's like a straight up line. Many times it's like curve, wave, and then sometimes you go backwards a little bit and it can go up. So in a nutshell, generally that's how an overview of the sessions, how the sessions kind of progress. And how those
and an ideal scenario for someone going through counseling will be happy to come out of it having a much clearer idea.
Yes.
How they are going to move forward lah.
Yes. And again, it's also about them coming to that decision point that, okay, this is a decision that I've made, and clarity about the decision. So counselors, we don't give you the advice, we don't make the decisions for you. We help you to process so that you can come to that decision-making point on your own and be grounded by it. Yeah.
Okay. I think this is a good point to move to the other aspects of therapeutic justice. Although I understand that actually this has been around a long time, which is mediation and other dispute resolution methods. I recall that a very large majority of divorce cases in Singapore are all settled in mediation. I'm not sure what the percentage is, Susan, maybe you'll know. And what exactly is mediation? Here, one party, first I have to satisfy eligibility, then I have to decide on the ground for divorce, then I may or may not have to go for counseling. Then the court says no mediation. So I imagine from a person's point of view, it's like you keep missing the court, you want to get the process going and then they send you out. But considering a large majority of cases are settled in mediation, I'm sure it's a fantastic resolution method. So maybe just tell us a bit more about what mediation is.
Okay.
Susan?
Yeah. You want to know the percentage of settlement?
Yeah.
For including partial settlement, a very high 90-odd%. It's very
90-something%.
correct. It's amazing.
That's
Okay.
very encouraging.
Yes.
Yeah.
Mediation settlement, very, very high percentage of resolution.
Mm.
So what is mediation? And okay, mediation is definitely not counseling. Okay. A mediator is a person who will help you navigate the process. All right. Now remember, mediation, importantly, it's about you making your own decisions. Right. So two people going through a tough time, marriage has broken down, can't talk to each other. This mediator will come in, tell you, okay, today we are going to try and see if I can teach you or navigate you through a process so that you can communicate to each other. Here it's not about rights. Here is about, hey, what really is the underlying interest, right? Somebody might say, both of them might want a house, for example.
Okay.
The person who wants a house can say, I want a house because I need a roof over my head for me and my children. The other person might want a house because, hey, I actually want to sell it because I need the money badly. So when you go to court, they don't ask you why you want the house, right? They probably will just say, okay, you want a house, you want a house. Nah, this is the fair distribution. After many, many years of marriage, this is your contribution. This is what percentage you can get. But at mediation, you can try to tell each other, what is your underlying interest? Okay, I want the house because of this, I want the house. So somehow there could be a resolution in the way that, okay, if I want a house for a roof, I have enough money for you to solve your money issues. It can be a very perfect solution. Okay, that's of course the idealistic way of looking at it. But beyond just the house, there could be many, many other issues. There's something like that. So at mediation, you're given this opportunity to explore all these things. Okay. And like I said, the beauty for me in a family case, what is the most important part of mediation? Apart from the obvious, shorter time, lower cost, okay, less aggravation, is definitely this thing about making your own decision. You can go to a court, the judge says, okay, you want access? I give you 50-50, sounds like fair, right? But both the parents will know maybe this is not practical. Right? The practical thing is the children also has a life of their own. They go to school, they have friends. Do they really want to spend 50% of their time with one parent, the other 50% with the other parent? So it's not quite like this. So when you have mediation, you can talk about all these things and eventually agree on something that will work. That's why settlement out of a mediation, the workability factor is also very high. And I have to tell all the audience here, from my experience as a lawyer, acting for both sides, I will give as high a percentage to people who are not happy with the orders, meaning a high 90%. Okay.
Oh, yes. Court orders, you mean?
Okay. Even if the court orders are in their favor.
Oh.
Yes. This is in particular for family cases. Right? Because it deals with so many things, the nitty-gritty. When can I see my children? When can I call my children? How much money is enough to maintain my children? Because this kind of issues are not like commercial claims. You owe me money, there's a contract, 100,000, you go to court, you get 100,000, blah, blah. It's not straightforward.
Absolutely, yeah.
The percentage of dissatisfaction is also real.
Yeah.
Okay?
That's very true.
Yeah.
And so, I think that you're right. So even if the court made an order that was fair, like you say, even in their favor, they can still be upset.
Oh, yes. Very frequently, Lian. I have, yes, it's some reality check for the audience out there. But having said that, of course, there will be people who say, no, I need my day in court. I need the judge to hear me. I need the judge to say some things to me to vindicate how I feel. Of course, there are, because how do I even begin on relationships, right? Where there are so many deep-rooted issues.
Yeah.
Right? Yeah. So where that happens and mediation is not suitable, the court will quite quickly actually divert the case before the court, before a judge.
Right.
Yes.
Right.
Yeah.
Okay. So now that mediation, okay, so the process first before we move on, right? Lawyers can attend.
Yes. So there are two types of mediation in family cases. One is in the family courts. This kind of mediation is before a judge mediator. They are free of charge, right? So usually you file your divorce already, then they set the mediation into motion. Your lawyers who are representing you will also be at the same mediation session. Okay, so these are the family court mediation, right? Then there is the private mediation, where if your estate is quite big, for example, I think it's 1 million or 2 million and above, you have to go to a private mediator because you can afford it.
Right.
Right. And if you ask me, because I'm a mediator, I'm also a mediation advocate, meaning I'm that lawyer who represents the clients in the mediation. Private mediation, there is going to be more resources for the parties to try and settle the thing. All right. So there will be more time for you, because court mediation, I think they give you chunks, like every session is 2 hours, and each time, if you cannot finish this one mediation session, they will give you another date, which could be months later.
Okay.
Right.
Yeah. But in private mediation, you can do everything in one whole day. Yeah. So success rate for mediation settlement in private mediation is also very, very, very high because of this.
Okay. Okay. So just now you were mentioning, right? Some cases in the end, they still go to court. So now while we are still on the topic of therapeutic justice, therapeutic justice in the courts, will it be treated differently now compared to in the past? How do you imagine the court or the judge is going to treat the matter? Because you see, before therapeutic justice, anyway, there was the mandatory parenting program, so there was some counseling already in place. Then the court also can order parties to go to mediation. So these processes are already there. How do you reckon it will be taken a step further, in the courts?
Okay. Very recently, I had to undergo a therapeutic justice course, certifiable course for lawyers. So they start the change from the persons. Okay. All the important players in this whole justice system have to change. Abigail, thank you for bringing out the incident about your clients showing you all the affidavits, nasty and mudslinging all over the shop. Yes, thousands and thousands of pages, right? So lawyers are now trained to be very TJ aware, how you write your affidavits, what kind of focus you must have when you talk to your client, okay? How do you try and encourage your client towards the peace mode rather than the war mode? These are all part of the course. And importantly, also lawyers these days are taught the social sciences of parties. Okay,
I'm so happy to hear that.
Yes, Abigail, now you all have to go and learn the law.
Oh,
We are learning about your
some exchange program that we should have.
No, seriously.
Yeah.
Last time in the 90s, you talk to lawyers about emotions. They will tell you, no. I'm here to tell you your rights.
Right.
You don't tell me all this emotional thing. You just run away. And then we don't understand, right? So funny, but at the end of the day, we are human beings. But when we wear the lawyer hats, we suddenly become like robots who don't understand emotions. Okay, but in the course, we learn a lot about emotions. If you are a family lawyer, you handle divorce, you must know that the divorce is the second most traumatic event in a person's life. How can you not deal with emotions? And as a person goes through that whole roller coaster, the kind of decisions, the kind of outlooks, right? It will definitely be affected by the emotions that he is undergoing. Yeah. So you will hear sometimes a lot of family lawyers saying, my clients always change their mind one. Okay. Why? Divorce clients always change their mind. The truth is, and this is something you learned, is that when you are very traumatized, you go through this state called the ambivalent state, right? Yeah. So things like this you learn. And then you start to be a lot more appreciative of what your client is going through. So these are some of the big changes that are going to be happening. and hopefully it will infect
Yeah.
okay, the whole community, and everybody will start adopting this way of dealing with cases.
Okay, so we've talked quite a bit about therapeutic justice, and the audience has quite a lot of very specific questions, which I feel is more appropriately discussed at the end of the session. But maybe let me touch on one or two which relate to topics that we've talked about. So before we move on to ancillary matters, so someone asked an interesting question. If, back to the simplified method of divorce process, if the couple agrees on everything for both stage 1 and 2, can they just use one lawyer?
Okay. In practice, no lawyers can represent two parties. Okay. However, if you think that you don't really care about your rights or whether what you have agreed affects your rights, you just want to quickly go ahead, it's quite common for one party to be represented by a lawyer and the other party is not represented by a lawyer.
Okay.
Okay, so one is got lawyer, one, you know, so that's how it's very common. But having said that, this kind of thing has got some repercussions actually for both the person who's not represented and for lawyers, right? Because a lot of misunderstanding can happen. This person who's not represented can misunderstand that this lawyer is actually representing me.
Right.
Right? Yeah. Because when you're going through divorce, it's like, you know, it can be a blur and then you don't remember things. Or this person who is not represented regrets what he has already, and then he will use this fact that, oh, I was not represented, therefore I don't know what I'm signing, to unravel the agreement that they have entered into. Okay, so the court actually required that the lawyer who's representing this one client, right, must repeat like 1,000 times to the other person that, hey, I am now telling you, you better get legal advice. Okay, and she must state it in writing, and she must also state it if she signs any draft order. Before, at where he signed, he must confirm that he has to seek legal advice, but he doesn't want to. Too many incidents of people regretting and then using this as an excuse to say, nope, I don't know what I was signing, no agreement.
Right.
Okay, so there is a question as well about women who, this is interesting, I'm not sure, okay, I'll just ask it. How does the court support women who experience abuse from husband and yet husband is unwilling to divorce, especially if the woman also happens to have committed adultery years ago? So I think this is a case of an unhappy husband, but yet he doesn't want to divorce her. This one sounds a bit like, I don't know, I would first seek a counselor's help. I don't know what is the legal step to take. Any one of you, I mean,
before Susan jump in with the legal part, I think when I hear abuse also, I'm also wondering if there are family violence issues, then you can actually apply for a protection order at the family justice courts, right? So again, if you're talking about, okay, different people have different ideas of abuse lah, so it's like, I poke you and then it's like, oh, that's abuse, versus like the continuum. So I think if there are really like signals and symptoms for family violence issues, I think that has to be acted upon, right? And then of course, if it's like the adultery, the unhappiness and all that, like what Leanne said, yes, please take it up in counseling. Yeah. So that's from my angle of the counselor.
From my angle, the legal point, once the abuse is established, it's unreasonable behavior on the husband's part. So you can definitely start divorce. All right. Some people who don't want to allege unreasonable behavior, then you start the whole separation process. Get separated for 3 years, get separated for 4 years. But of course, that's a very long time. Yeah, but if there is really abuse, well, it's unreasonable behavior. So you can go on that fact to support your divorce.
And the fact that you had previously committed adultery makes no difference.
Well, yeah, because he's accepted that you have committed adultery, and yet he still wants to carry on marriage with you. So he cannot use the adultery as a reason for his divorce. You know what I mean? Because he's accepted the thing already. Remember, I said you must find it intolerable to live with. You cannot allege something that happened years ago and say, oh, this is your unreasonable behavior or your adultery. Yeah, it doesn't work. I hope that answers the person's question.
Yeah, me too. Okay, this one is interesting. How enforceable is the signed separation agreement completed during mediation?
Very enforceable. Simple question. Yeah. But especially if it's in a mediation whereby you're represented, that means you have mediation advocates or lawyers, and then there is a mediator. Okay. And it is pursuant to, like, let's say after the divorce, proceedings have commenced, it's enforceable. Right? Yeah. Because you will file what you have agreed into an order. I hope that is the question that she's asking. Because what happens if you go and mediate and then you never really went through the divorce process? Then it becomes like an agreement, and I will have to say that kind of enforceability can be slightly questionable. But that's a very big topic, and I don't really want to go into that at the moment.
Yeah, because I think it really depends on the circumstances surrounding it. Right? Yeah, the evidence and all that. Yeah. Okay, quite a number of questions relate to ancillary matters. So let's move on, and then after that, let's move to Q&A. So this segment of our talk, right, we're going to talk about the stage 2 of the divorce process. So just to signpost for all of you, this is known as ancillary matters. So the interim judgment has been given, and now we're going to talk about care and custody of children. We're going to talk about maintenance for the spouse or the child or both, and then we're going to talk about division of matrimonial assets. So if you have some more questions on these topics, please maybe listen first to the speaker. She might have already explained certain things, and then feel free to ask your more specific questions along the way. Okay, so let's start with the children. Custody, care, and control. What is the court's overarching position about the children, Susan?
Actually, it's really just one sentence. Issues relating to children, the paramount factor is best interest of the children. So parents must step out of their own shoes and think about what is going to be best for the kids. That's that one line, really. What it means really depends on situations.
Yeah. So maybe we just talk about the 3 aspects, and then as we talk about them, we can discuss if there are certain case studies or examples that you can give, when it comes to each of them: custody, care and control, and access. These are the 3 aspects, right, of children matters. Yeah. So shall we just run through them, and then along the way, Abigail, I think the topic of children, a lot of counseling related issues, to be discussed. Definitely. So let's just so chip in whenever. So shall we start with custody, Susan? I actually didn't anticipate, but I realized there are a lot of people fighting for custody. Like they don't want to share custody in a divorce case. Which surprised me actually.
A lot of people think they want to fight custody. When they go and see a lawyer, if you're a family lawyer, you will know this might be a fight in futility. No point. Okay? Why? Because the default is almost joint custody. Now let me go into what really is custody. Okay? Custody in Singapore means the authority to make major life decisions for the kid, for your child, right? So what kind of decisions? Education, health, religion, surname, right? So these are big life decisions. Now in Singapore, they split custody with care and control. What is care and control? Care and control is your daily care routine, where this kind of daily decisions are made, right? The resident of the child will be with the party with care and control, and then that parent will then decide on all the daily things. Okay, including like medical issues. If it is just like, okay, I have a cold, I bring him to which doctor, right? Now, what is access? The parent with no care and control will have access rights. How often do you get to see the child? Weekends, do we have overnight telephone access, overseas access, things like that? So these are the three simple definitions.
Okay. On the topic of custody, right? Because remember earlier we were talking about international marriages. So I have definitely heard of couples who enter, it's like maybe custody seems to have become a bigger issue for couples who are, maybe one is not resident in Singapore or wishes to move overseas for good. I don't know whether that is still care and control or custody, but definitely two questions. One, can you be living in two separate countries and still share custody of the child if the child is obviously following one parent? And then the other thing would be the emotional, I was going to say trauma, but I don't know whether that's too heavy a word, but you know, Abigail, for children, I think it must be quite difficult to be in the midst of a situation like that. So yeah, I don't know whether you've helped parties in such situations. Susan, you want to talk about the legal aspect?
Firstly, in Singapore, once the whole issue of custody, care and control could be very different in different countries, right? But in Singapore, the answer to your question, can two parents share joint custody even if they live in two different countries? The answer is actually yes. Okay. Now, what does joint custody also entail? The decision or the right to decide where the kids will live, which country the kid will live. That's why people will want to fight for sole custody, because then I have the single right to decide. If I want to move out of the country, I just move. I don't need your consent. Okay. So that's joint custody. Yes, of course, you can have joint custody even if you live in America and I live in Singapore. Right? And the kid is in America. So care and control is usually given to the primary caregiver. If you're the primary caregiver, tend to be the mom, right? Then it's with the primary caregiver. Now, relocation issues happens a lot with people who move, right? And usually the spouse will move with the person who has a job. And that person who moved without a job usually cannot find a job. Right? Yeah. So when you are here in Singapore, you move because of your, maybe your husband, and then suddenly the marriage falls apart. And your family is not here and you want to go home because the sole reason for why you are here is already gone, right? The marriage is gone. Now, the problem is you can't just decide to go home if your husband doesn't consent. That's how it is, right? So you need to apply to court to relocate. I will leave Abigail to explain the trauma to a child if you just take the child away and then the parents start fighting over custody or care and control of the kid. Because if you don't get the approval of the court, there will be, of course, one party who is very antagonistic against the move, right? And he or she may do everything to try and stop you from doing that. That's why the litigation will escalate. Okay. So maybe, Abigail, you want to talk a little bit about that?
Yeah, I think also whether is it just transnational relocation and all that, children, depending on the age that they are at, there are different, they are in different stages of development. And what that means also is that at different age, the meaning making for them in terms of what's happening around about them, the experiences, the meaning that they have, can look very different between a young kid and an older kid. So a phrase that I say very often, children are great observers, they are pretty lousy interpreters. Okay, so it's not that they are not aware, they observe, and if you've been around young children a lot, you might notice that they actually pick up a lot of details and they pay attention to a lot more things, sometimes even more so than us adults. However, the meaning making that it has for them can sound very distorted and very warped. if we were to verbalize it. And that is where we hear a lot of times where children will say that it's my fault, it's because of me, that's why mommy and daddy are fighting. It's because of the interpretation that they have, right? Oh, I want to have McDonald's. And then mom and dad says no. And then the next thing, I see mom and dad fighting. Oh, that's because I wanted McDonald's. That's why I caused mom and dad to fight, right? So similarly, if we are talking about relocation, imagine the kind of meaning making where suddenly one parent brings the kid out of the country, no explanation, nothing. What meaning making possibly could the child have, right? And this is regardless of if the child is a young child or an older child. And it's also a myth that they are so young, they're not going to remember. Okay, because when we look at memory system or we look at brain development, the narratives tend to come on board probably from the ages of 2 to 3. But anything before the age of 2, it's not that we don't have memories or recollections of it. We do have, except that we do not have that verbalization narrative of it. So many times what then happens is that we experience it somatically. So these are kind of what we call like implicit memories and all that. And so many times for these children, when they grow up and they find themselves in very similar environments or something similar that happens or an argument, they have an emotional or behavioral outburst, and the parents are like, where did that come from? And even the kid doesn't know, because it was something that happened when they were a lot younger, that the brain doesn't necessarily have that event to match. So in terms of working with helping parties like these in such situation, again, it can sound very simplistic, but the whole process, of course, it involves so much more. I encourage parents, first thing I always tell parents, no matter what, you are always going to be the child's mom and dad. You cannot remove that. You are no longer each other's husbands and wives. You don't have to like each other. You don't have to be each other's best friends, right? But you are always going to be this child's mom and dad. So how can we work together on a shared narrative that can be presented and explained to the child? And what I mean by shared narrative basically is factual information using age-appropriate language, depending on the ages of the children that's involved here, versus personal attack on characters or projecting blame. Yeah. And then on the side, kind of also, I think educating parents on the strain of a child who has to spend different periods of time separately with each parents. So sometimes I hear parents complaining to me like, oh, my child's been very cranky, my child is very tired. Yeah, I mean, other than the fact that they have long days in school, imagine, back and forth. And for some of them, where one parent is in one country, the other parent is in the other country, I mean, pre-COVID, pre-VTL, and they have to travel back and forth. It's not easy for a child. Yeah.
One last quick question, right? Before we deal with now the Q&A on this topic, it occurred to me, I think sometimes, I imagine quite often, say the marriage is broken down, parties have divorced, right? Parents also feel with guilt, right? It's also not just, okay, so we think of it as the parents are fighting, then the poor child is very victimized.
Yeah.
But I would imagine, I mean, if I put myself in the shoes and no choice, when the marriage is broken down, but I'll be very guilty. I see my child so poor thing, weekend got to be with another.
Yes.
So I think that the counseling will help with that as well. I think acceptance of the situation.
Yes.
So because I think another danger could be, or it's a question, that the child, sometimes children can use the parents' guilt. Then it can become an unhealthy relationship.
Yeah, I think 2 points on that. One, I think for the parent, and why I'm a counselor, and I advocate so much for that, it's because knowing that with that guilt sometimes, and then your child is with the other parent, and how do you welcome your child back into your presence? So if your own container is very limited and you're melting down and you're having breakdowns, you're not going to be able to provide that safe cascade of care for your child. And I think that's really important, particularly when your child comes back into your presence, and the nurture and the love and the care that you can give towards your child. I think that's one aspect. Now, there are, yes, of course, kids, in many times in divorce situation, we see kids who are very apt at playing off each parents. They know how to get at each parent. And, so that's why we also need to kind of work with the kids on those issues. However, interestingly, Leanne, recently I've also seen kids, and we always think like kids, they don't know anything, or they are like supporting their victims. I've actually been seeing kids in from such families who are very well aware of what's happening, and they try to protect the parents. So what they then do is they portray that I'm doing well in school, I do my homework, I'm a good kid, I'm happy, I'm not feeling sad, I'm not angry, I'm okay, I'm a happy kid. And that sometimes is their way of protecting the parents, so that my parents are going through so much, I really don't want them to worry about me. I mean, it sounds lovely, except that when we think about the pent-up emotions and all the things that the child carries, and it doesn't feel like they have that permission to be able to release or even to share with their parent about how they are feeling, because they want to protect the parents.
Yeah.
That's rather concerning to me.
Agree.
Yeah.
Okay. Yeah, I thought that was very useful. Okay, so let's deal with some of the questions regarding like access and all that, right? Here's a question. This party says, what if we can't agree on child access? For example, both my spouse and I, we want the child to be with us for CNY reunion dinner. Will the court intervene to decide whom the child should have dinner with? And then there is another access question. Access is very specific on timing and days. Is there a way around it? I thought there was another access question, but let me find it. Let's see. No, I think that's it. That's it.
Chinese New Year reunion dinner. This topic is so serious that one case went all the way up to the Court of Appeal. And then in that case, the judges defined therapeutic justice, said not very nice things about the lawyers, because it's very sad.
Yeah.
Right? I think, it's a family where they have 3 grown-up kids. Both the grown-up kids, if I'm not wrong, are not in Singapore. Okay.
Oh.
But the one kid where they had to go to court about, I think he was already quite old, a teenager. And yes, the topic was CNY dinner. One party insists on this time, and the other party also needed this time. But at the end of the day, so this is that one case, right? We have thousands of cases where parents, please don't feel that this is an attack, but I do need to praise these parents because they are sensible, and they have decided to alternate. Every year, this year you will have on this night, on the eve. Next year you have on the eve. That works, right? You don't have to every year also have it at a specific time. Because a family has broken down, you need to make compromises. So that's one aspect. Non-agreement on access, super common. Access has become such a big contentious point, right? It gives, usually 2 parents don't see each other. But at the time when you hand over the child, maybe you see each other.
Yeah.
And of course, that's the time they will fight the most. And that's the time when the kid will see 2 parents together at the same time. Each time this happens, they are fighting. Okay. So the trauma the kid feels about this handover can be so bad that they will act out. Abigail, you were talking about kids who pretend to be perfectly okay. But many times they had to come and see you surely because they act out in some other ways that cause concern to their parents. Right? So parents, they can fight all they want about the access and they think they win. But at the end of the day, when the kid acts out in terrible ways and you cannot cope with the kids, who will lose? You will lose. You might even lose your kid. When they grow up, they will, they might just really not want to be around all these negative energies, right? While you traumatize them. But like I said, so how do you come to an agreement? Some of the support system will include parenting coordinators. They include people like us who have seen many, many, many cases telling you, okay, what would be a sensible solution, right? The other thing I want to urge parents is this: life is full of uncertainties. Don't think that if it is 7 o'clock, every single time it will be at 7 o'clock, right? Some days it might be 7:30 even, or even 8 o'clock, right? Because things happen. You may have to be at work later. There might be an incident, okay? And it's not just one party. It can happen to you too. So the whole idea about access arrangements is flexibility. Don't be so hard on, okay, I really need you to come in by this time. No, flexibility is key. Of course, when you marry somebody, sometimes some people are a lot more flexible with their timing than you are. Could be a reason why you divorced him. But that's how it is, right? You have to deal with it. Okay, so if you're married, you have to deal with this. If you're divorced, same. That's my 2 cents worth lah. Abigail, you
yeah, if I can just add on, and again, I know that it's easier said than done because I'm also kind of in that category. But think about your child, look at your child before responding to your own responses and reaction. Because 7:01, wait, hang on, the access timing is supposed to be 7 o'clock. Why are they not here yet? Right? And then when the other party comes, there is this springboard of like lashing out. That's from our reaction and our response. Look at your child. Think about your child first. Yeah. Again, I said easier said than done, right? So if it's challenging for you, think of something that's just really practical that you can apply in such scenarios.
I think that's super useful.
Yeah, because if not, I just recall like a situation where it's like 7:01, right? Not here yet and all that. Because guess what? After that, when the child goes home with you, you know what? You have to deal with the meltdown of your kid, and that's not fun. Yeah. So if you're having a full-on argument and lashing out, and your child is in the heat of it, sure, you may have your child back with you, but you have to deal with the repercussions and the consequences and all that. And some of them are just not pretty.
Yeah. Very, very good reminder. Okay, this one is a bit of an enforcement question. So we'll quickly talk about it because I'd like to move to maintenance and then answer all your other questions. It's about kids access. This question is, how long is kids access if it is silent in the judgment? I'm not sure why it's silent, but that's what the question is. And until what age, of the kids does access sort of stop being applicable? And what if the children don't want to go to the father's place? Do they have a right? And finally, how do we go about varying kids' access in the judgment to account for changes in circumstances after a few years? Somebody mentioned something like suddenly they need to study very late. So how to change the access arrangement? So maybe just a quick few words.
Few words. 1, 2, 3. Yeah, I think this person, I'm afraid, is almost asking for legal advice, which is not wise to get it from here because, for one, we know no background of the case. Secondly, we do not know the terms of the order. We don't even know how old the kids are. Okay, but if she's telling me these are the issues, I'll tell her it is quite common. It's quite common. So the sad thing is people keep going back to court because they are unable to resolve this between themselves. Hopefully, with the whole therapeutic justice lens, the court system will provide this kind of support. Because with counseling, co-parenting counseling, with a team of professionals coming together to hopefully guide the parents towards better co-parenting, right? These kind of issues will just go away. Right? Yeah.
Okay. Okay. This one is about a special needs kid. Actually, it covers a bit about maybe maintenance or something. So let's find out later. I think I'd like to move on quickly. But a quick question about care and control. Can it be split 50-50 or is care and control is always one parent?
My personal preference in an ideal world is shared care and control. So it's not 50-50 care and control that way, but it's called shared care and control. These days it's getting more and more common. But it works best if both parents can co-parent beautifully. They think for their child, this is a really ideal situation.
Right.
Because then the kid will feel really secure. Yeah.
And I just want to add on that I have actually seen co-parenting work successfully. And they are not best friends with each other. And they still don't like each other.
Yeah, that's encouraging. Okay, moving on to maintenance. Susan, let's just talk about what it is, who can apply. And I think one common question that I used to encounter was whether you can apply for maintenance before divorce.
Simple answer, yes. Definitely, you can. You don't need a divorce to apply for maintenance. And I want to just add this. The court is making the process for applying maintenance more easier and easier. These days, you can do it even online. You don't have to go down to court anymore. You go to the IFAM portal, okay? And then you can apply through there. So there are two kinds of cases with the biggest numbers. One of them is maintenance. So what the courts tried to do is to make it very accessible, very easy.
Can it be abused? I mean, like, I'm just thinking from the position of the other spouse, then if one spouse keep on applying or maybe ask for more money, possible lah.
Yeah,
that has to go to court.
Going to court is not something fun. And sometimes if you want to keep doing it this way, it's a full-time job.
Oh, that's true.
Yeah,
good point.
And you will go to court and you will find out, oh, the court they're not like, they're not blind to all these efforts, right, to try and make the other party suffer. They will know, and you will soon realize it's not worth the effort. Okay, but the court is about giving reasonable maintenance and helping those people who really need maintenance to try and apply for it.
So who easily? I don't know whether it's a fair question, but who are these people? I mean, let's say now I'm in a situation, I need, I think child maintenance is probably easier, because if I cannot afford to support my children without my spouse's help, I definitely can apply. I don't know whether evidentially is that like very difficult. Like, how do I show that, I need X dollars from my spouse for my children, and I'm not going to spend it on myself to buy shoe and handbag and all that, right? What does a party need to do when they apply?
So, like I said, the whole system is making it really easy. They give you a form, you fill up. You got to, of course, itemize your expenses. And where you can, you must support these expenses with documents. But sometimes you go to market, buy food, they don't give you receipts. That's understandable. So not everything has to be supported by receipts, right? But big ticket item, I have tuition for my kids. I have to spend $2,000. That kind of thing, sure, you will have receipt. So you just support them with receipts and tell the court that this is what the child need and this is what he used to provide maintenance for. Please make him pay maintenance. Now, I want to briefly touch on, since you're on the topic of maintenance, maybe I just give everybody a general view. Who can apply for maintenance? Definitely you can apply for maintenance for children, the caregivers. So if you're the father or the mother, you're the caregiver, you can apply for maintenance, whether you're man or woman, for the children, okay? Wives can apply for maintenance for herself if the husband has been maintaining her. These days, women are very successful, often more successful than even their spouse. So not in all situations you will get maintenance. It's no longer like, okay, for sure, all women will be able to get maintenance, okay? Third category is a husband can also apply for maintenance, but the bar is very, very high. He is unable to work. He must be what we call incapacitated. Then he can apply for maintenance from the wife. Okay, those situations are very rare, right? But it happens. So these are the three types of maintenance that you can claim.
Okay, so now that it's so straightforward, those factors as to whether what the courts look at, the age of the parents, the financial needs of the child, I think now it's basically less, right? Unless it becomes a huge battle during divorce.
Correct.
And I imagine it's for very high net worth parties, maybe.
Yes, correct. But in most cases, the three main things they look at is income of the parties, right? Because children's maintenance must be contributed by both sides, not just one side. All right. So income and expenses, and if the child has special needs.
Right.
Yeah, so
Okay.
these are the three main things the court will look at. Like the rest is like, okay, the standard of living and all that is very incidental, more incidental. Yeah.
If there's a party, right, who maybe during the course of a marriage finds himself or herself shouldering a lot of the children's expenses, financial needs, because maybe he or she is unable or finds it very, very difficult to obtain maintenance from their husband. Is that going to affect his or her application, say either during divorce, or let's say just suddenly, she wants to try or he wants to try to apply for maintenance for the child, right? Then wouldn't the argument be that, but anyway, for the past 10 years, you've been the one paying what? Why now you ask me to pay? Even though perhaps it could be like a whole 1/3 or 40% of that person's income spent on the children. I don't know.
The court will not be persuaded by this kind of argument for maintenance for the children. For maintenance for the spouse, maybe. Like, hey, you never needed maintenance from me. Why you suddenly need maintenance from me, right? For yourself. Especially in a case where the wife has been working and pretty successful. But for children, if you're what do I call a kind of a bit of a irresponsible, if I may use this word,
yeah,
when it comes to finances, right? Just because you haven't been paying and you didn't want to pay doesn't mean that the court will not order against you. In fact, for children, it's very like a lot more straightforward. What's your income? What's the needs? What's the expenses?
okay. Okay, that's good to know. There's clarity there. Okay, one quick question on maintenance. What happens if my husband always misses the maintenance payment or insists that children above 17 years can work and study to support themselves?
Okay. No, if the child is still studying, just because he can go out and work, okay, and by the way, I'm not sure he can go out and work just like that since he's underage, doesn't mean that he doesn't have to support him. But if the child, in fact, really just left school and is now working and can support himself, then yes, maybe he has a reason for why he can stop or lessen the maintenance, number one. Number two, there are many people out there who default on maintenance for children. So there are ways, and in a special way that only applies to maintenance is attachment of earnings. So this is a very big thing. You can attach his earnings, make his employer pay you directly.
Before paying him his salary.
Yes.
Wow.
So that's a very powerful tool.
Yeah, man.
Yeah.
But of course, you must have real. This is necessary because it can be quite a big thing, right? Firstly, for the employer to know, oh my God, you're this kind of So that's
the idea is that it's a good deterrent, lah. So if you really want your employer to have to do that, then you better be paying your maintenance.
By the way, defaulting in maintenance also, wives can report to credit bureau. That's the other tool. Therefore, this person's credit worthiness plunge the level, and he may have issues getting bank loans and all that, because it will show that he defaults on maintenance.
Right, that's useful.
Yeah.
Okay, one last question. Is the wife expected to also contribute towards children's expenses?
Definitely, if she's working.
So it's a shared duty, lah.
Yes, it's a shared duty.
Okay, moving on. Let's quickly deal with two more questions and then we'll hit the Q&A. Quickly, division of matrimonial assets. Susan, what is the court's primary objective? What's the rule, or the principle under which it is done in Singapore? For some reason, a lot of people, like I said, right, in the old days, have this impression that it's 50-50. If the husband did something bad, then the wife will get more. Otherwise, it's at least 50%. But now with dual income, sometimes the wife can earn more than the husband and all that. I don't know whether the principle, when applied, will actually produce different results.
Okay. Just like best interest of the child, there's this big statement, okay, or big principle that the court will rely on when it comes to division of matrimonial assets, and that is just and equitable. Okay, this is the phrase that the court will use. Effectively, it means a fair distribution. All right, so what will the court consider as fair? What kind of factors they look at? They look at length of marriage. 50-50 applies to very, very long marriages where one party is a homemaker, a caregiver, the other party is the breadwinner. Okay, so that kind of situation, we often advise the clients, hey, there's a case law here, it's 50-50. Long marriages, one party homemaker, one party is breadwinner. Okay, so length of marriage. Otherwise, they look at contributions. What are the contributions? The direct contributions will be like money that you pay to acquire these assets. Singapore biggest asset is definitely a home loan, usually, okay, for most people. So how much do you pay for it? That's direct contribution, that's financial contribution. Then there is indirect contribution, which is if I'm a homemaker, then my indirect contribution will be the amount of homemaking I make. Because of what I do at home enables you to go out there and earn money. So these are also my contribution. All right. So that's contribution. Then they will also look at things like needs of children and whether parties have already agreed on how the division is to be made. So a rule of thumb, long marriages, maybe 50-50, also like one homemaker, one breadwinner. Short marriages, the court tend to look at financial contributions to then establish the percentage. Oh, you contribute 90%, you contribute 10%. Okay, so it's 90-10. Tend to be like this. Yeah.
Okay.
But this whole area is it's actually it's an area that you really should seek legal advice because it's too generalized, what I just said. Yeah. See a lawyer because your situation will be very, very different. You have a short marriage, but you have 3 children. That's not like, that may not be direct financial contribution already. So, okay, don't just take my word for it as,
Yeah, because definitely case by case basis. I think it really depends on the arrangement in the family, right?
Yes.
Like maybe, you know, I don't know, like very large family, the homemaker is doing a lot, taking care of parents in the house or whatever.
Yes, correct.
Okay. So with in view of the shift towards this therapeutic justice, is it maybe right now still a bit too early to talk about whether the court's approach might be slightly different now? When it comes to division of matrimonial assets? Or do we anticipate that it will be more collaborative or what?
If I say this, I'm very worried I will confuse the audience. Because there are academics, very prominent academics, who are advocating 50-50 because they think that marriage should always stem from an equal basis. Okay? Yeah, but that's the ideal situation, right? A lot of people don't see it this way, right? It's not like, wow, just because you get married then immediately it's like fair and equal. So I feel that things may change, there may be changes, but at the moment we don't know how and where.
And more importantly, I think best to seek legal advice.
Yes. Yes.
Because every case is a different case.
Definitely.
Yeah. Okay, so I want to quickly jump to Q&A. But one question about lawyers. You know, earlier you talked, Susan, about how the role of the lawyer also changing. You just attended a course about therapeutic justice, and you know, you even have to rethink. This is my question. So when a client now goes in search of a lawyer, how will he or she know that, hey, my lawyer is up to date on the court's expectations, and you know, my lawyer is encouraging me to pursue this matter in this manner. Yeah, so what should I be looking out for? When I cold calls, I ask my friends to recommend, then I go to 3 different lawyers. Usually last time in the past, it's just to get a quote, right? But I'm sure for participants, now that they've heard all this, they may want to look for a lawyer who is able to go in the direction that the courts are going to. How to tell?
Actually, this is a really important question because most of us don't know how to pick a lawyer, right? Like I just suffered an injury. I also don't really know how to pick the right doctor for myself. So, so please excuse me if I may sound like I'm repeating myself, because to me, I feel this is an important question. In this TJ regime, right, what kind of lawyer do you want to look for? And what should the role of this lawyer be? One thing is very clear, I will stress again, this lawyer practicing under this family law, the TJ way of family law, must definitely possess the skills to understand emotional, psychological state of a person undergoing divorce. Can't stress enough, top 2 trauma, this person going through divorce will not behave like how they normally behave. But beyond just ending a relationship, divorce is also about making many, many decisions. Okay, you want to have control over these decisions instead of letting a judge make those decisions for you. That will mean looking for somebody who can be equipped to help you make these decisions, knowing that you are going to be all right in the future. Okay, so these lawyers usually will work with counselors. Like, if you are in the right state of mind, you will make the right decisions. And I will stress again, fighting in court, yes, you may have Chinese reunion dinner problem, but going to court over this kind of issues, right, proven again and again to be very damaging. Not damaging to you maybe, but definitely damaging to your kids, right? So again, this lawyer must be able to see what you cannot see. They already look into the future and know, okay, you continue to fight this way, something is going to break. And that's likely to be okay. And that person you must trust and respect, because this person will tell you things you cannot see at the moment, right? When he or she is unhappy, right, she will just react to revenge, hurt, anger. Is very common, right? They will tell you, no, this letter is very rude to me. How can you say it so nicely? I want you to also be rude to them. What is the point? If a court is telling lawyers, go for this course, go and do a TJ course, do you think the same court is going to be understanding when they see a rude lawyer from rude letter from your lawyer? I don't think so, right? I don't even have to tell you what the court is going to feel because I don't know, but this is just common sense, right? So it is also no longer about how you can win in court. As a lawyer last time, it's about you going to court, your rights and all. But a TJ lawyer is going to be focused more on, okay, even before you start divorce, how can we work with each other? Remember joint problem solvers, right? To see if an agreement can be reached. Maybe not on everything, but on most things, so that in the end, the whole process in court is very straightforward. The hard part is in the before, right? It's not in the after. Okay. If that is the case, then chances are your future is going to be okay, both for yourself and for your kids. So this is my answer to a role of lawyer.
I agree. Okay.
I think I wanted to add a little bit also. It's also like a win-win situation for all, because even from the perspective of a counselor, I really don't want to see people 10 years later and still coming and then crying over the thing, and then the kids are still affected, traumatized after like 10 years. It's really it's heartbreaking, even for me to see. So
and there are cases like that. Very long-term clients. Agree. Okay. I think we've covered quite a lot today. Let's try to cover as many of the questions that have been asked. Oops, let me find my. Okay. So, okay, we've dealt with access. This one is a legal question. Can I file a divorce against my husband who is serving long-term custodial sentence in prison? And how will he attend counseling sessions, or will counseling be waived? I think this person is probably referring to the MPP So maybe Susan, you want to explain. So I think this one is one spouse is serving custodial sentence in prison, and she wants to know if she can divorce the husband.
Yes, it's not uncommon.
Mm.
I at the moment, MPP need only be attended by the party suing. That means the party filing the divorce, not the party who is responding to the divorce. So if your husband is in custodial sentence, he's not the one filing any claim, he doesn't have to attend. Yeah. By the way, MPP is now attended through Zoom.
Yeah, it's online.
So yeah, it's online. So I don't know whether the prison has facilities for this, but yeah. In
So
any
unless,
case,
if he's not the one filing,
correct,
then
he doesn't have to attend. Yeah.
Okay. This is a question about divorce with mutual consent. I'm not sure we can answer it yet, but we can talk about definitely the simplified track, because the question is basically, how fast can I get the divorce?
Short answer to that, from the time you file until the time you get your final judgment, maybe 4 months.
Still 4 months.
Yes, 4 months, because you need to have that 3 months, Lian. Okay, I don't know if you remember, for the audience, whether they remember, if you get married in Singapore, you need to wait after you put in your registration. You need to wait for a period of time before you can get married, because you need to see whether anybody filed an objection to your marriage.
Put on the notice board kind of thing.
Yes.
Correct. So this is the same thing. After you get your interim judgment, which is your stage A side, right? 3 months must pass, even if all the issues to stage B is done, before final judgment can be given, because of that notice, the 3 months. Yeah.
So it's actually 1 + 3, and that's why it's 4.
Yes, it's 1 + 3.
And this is for simplified track, meaning everything is agreed.
Correct. Now, some people will expedite this, and if you have very good reason, you can apply to shorten that 3 months.
Oh, really?
Yes.
Okay. I wonder what the very good reason is.
You are already pregnant and you need to get married urgently.
Oh, I see. Okay.
That's one reason.
Right.
Yeah.
Okay. Okay, I think we've dealt with that one. This one, easy lah. Can a wife seek divorce from her husband if his drinking habits are going out of control?
Definitely. Unreasonably.
Yeah.
Except that in this case, we would have to be objective about what going out of control means. Because I can share a personal story. My grandmother, so this is all like really old history. She was so mad with my grandfather, and she considered him a drinker. But you know, my poor akong basically likes to have one stop every day lah. In today's standards, it may not be going out of control, right?
Correct.
But it depends on background and all that sort of thing.
Yes.
So I think
there are reasonable standards that the court goes by when you say somebody is unreasonable. So not just because you think it's reasonable, it's reasonable. Okay?
Yeah. I definitely, personally encountered that. quite tragic and traumatic for both parties. Okay, will we be discussing annulment? I guess you can quickly talk about it unless it's a big topic. Because this person is asking about making the marriage void before 3 years is up.
Annulment, you don't have to have 3 years of marriage. It can be immediate. Like annulment, what happens, right? So if you have never consummated your marriage, you can annul your marriage. At the point of time, the person that you're marrying, I guess is your wife, is pregnant with somebody else's child and you didn't know, that's also another ground for annulment. Mental capacity, this person don't know what marriage is all about. So there are all these situations where you can apply for annulment. Yeah.
But quite unique. You can't, because you've gone and failed the 3-year marriage rule, then conveniently say, oh, in that case, let's annul. It's not by agreement as such, right?
Last time in the 90s, very fashionable, if I may say so, to go on annulment because they don't want, well, some people don't want to wait for the divorce.
Yeah.
So it became very common. You go to court, sure got cases about, I have registered my marriage, but we never go to, we never have the tea ceremony, so we never have consummated the marriage. Okay, so it became really like a common ground, a common factor people use. Until one judge say, why you cannot find the right tea leaves, is it? I remember I was asked this question by the judge. But and so the court is wise, it has wised up to all these things lah. So be careful when you want to apply for annulment. Yeah, they really will. You know, simplified divorce, by the way, if you go on annulment, right, there is no such thing as no hearing. You have to go to court. The judge will question you. So you know, I didn't say that simplified divorce, you actually didn't even have to attend that court. Okay, but for annulment, no, you have to go to court. Parties have to all go there. The judge will question you. May not be a nice experience, so be prepared for that. Yeah.
Right. Okay. Okay. This question about maintenance seems to be very technical because there are a lot of dates. I think I'll leave it to you, Susan, to advise if this is a case that this person should seek specific legal advice. It says matrimonial asset is HDB. Division is mentioned in interim judgment, supposed to be sold in 6 months. But the flat was in the end sold, but out of time. So since the sale is out of time, is it considered like didn't comply lah? And can there be an objection to the sale?
Yes, you're right, Leanne. Please seek the advice
Yeah,
from
very
the lawyer
specific,
who
right?
represented you when you get this order in the first place.
Okay. If the court has ordered for the HDB to be sold, but then the other spouse refuses, it just like sounds like an enforcement issue lah.
Definitely.
You can just apply for it to be enforced, right? It's in the court order.
Correct. Now, just a quick one for this one, not uncommon, this kind of issue. In fact, there is an empowerment clause, which you see the husband don't want to sign, right? That can empower the court to sign on his behalf. So go to a lawyer, go and get it enforced this way. It can be done. Yeah.
Okay, that sounds good. Okay, let's look at the last few questions before we move on. Okay, this is a cute question. It is quite scary that one can get divorced in just 4 months. Is it making things too easy? Do we need to give couples time to work out and try to reconcile? I mean, so let's say I think what this person might be saying is that in a simplified track, you know, are the courts sort of because you say they don't even have to attend court, right?
Yes.
And going forward, divorce by mutual consent is going to be in a way even easier.
Even easier, correct.
I would imagine that if this person is a party to the relationship, then and you feel that you want to reconcile, then what do you think, Abigail? The way to go about it is don't simplify track lah. Don't do divorce by mutual consent, right? Because that lengthens the period and maybe ask to go for counseling or something. I'm speaking from the perspective of maybe, you know, my spouse is like pushing me, we need to do this so that it can be done very quickly. And insisting that I have to agree on all these terms so that we can go simplified track, right? But if in my heart, I want to try to reconcile or work it out. Actually, this brings me to my final question. Just nice, right? Because we are reaching their time. I wanted to ask you this, Abigail, and maybe Susan, you have personal experience with clients as well. I feel that in marriages, often one party is a weaker party. One party sort of has an emotional hold over the other, so much so that like there's a bit of power imbalance in the marriage. So when you want to, whether it's broaching divorce, whether it's you know, so the stronger spouse says, oh, come, let's sit down, let's agree on all the terms so that we can, you know, have a divorce by mutual consent or something. Any advice for what someone who is always in a weaker position should do? I mean, if I have friends who are like that, I'd be worried that you don't go and agree to everything, because you don't know how to say no. Because like Susan, you've always said, there are many decisions to be made. Some of them impact you, but some of them impact your child. So in your counseling sessions, is there a way to guide such people so that when it comes to making the decision, it is a more balanced and sensible one?
I think kind of backtrack a little bit just now when we were talking about what's the role of the lawyer and then how do you go about, right, looking for a lawyer. I think similar principle here in terms of looking for a counselor. You want to make sure that the counselor is registered, the counselor has the relevant training to deal with couples or to work with a separation and divorce issue. And really, you can actually ask counselors when you're kind of checking them out, and contacting them, say, hey, or even go to like the Singapore Association for Counseling website and check if they are a registered counselor. So for me, like even as a play therapist, there's a registration board, right, that you can kind of see, okay, legit or not, are they registered there? I think that's where, that's where as a counselor, that's where we go for training and we learn, right, skills in terms of not just observing, but we look out for such dynamics that take place when we are seeing both couples, when we are seeing the couples and we are seeing both parties. So learning to recognize and to identify that on the part of the counselor, as well as being able to gatekeep so that both parties actually have equal voices and be heard. So while we may not necessarily be a mediator, we can apply some mediation skills during those sessions. And again, when it comes to marital or couples session, it doesn't necessarily always mean that both parties are in sessions. So when we kind of notice that, okay, there's this kind of power imbalance, for whatever reason, one person is talking the whole time, the other person doesn't seem to be able to have a voice, we can actually say, okay, how about let's just kind of separate for a while, let's just have individual sessions, hear each other out, and then let's come back again for joint sessions, right? So that's where individually, hopefully, you are able to provide a safe space for the other party to be able to voice out some of the concerns that they might feel maybe a little apprehensive in not sharing when the other person is around. Yeah.
Good point. Susan, anything to add?
Oh, definitely. Okay, so I've said a lot about a TJ lawyer, how to be nice, how to be peace approach and all that. But importantly, right, it doesn't stop us from kind of being the bodyguard as well. A client comes to us and one of our primary role is to advise her of what is reasonable, her rights, and what would the court say, this is reasonably yours. For a party who feels that, hey, I don't dare to do this, I don't dare to do that, then my job is to protect her in a way that I make sure she gets what I think she should. Okay, so that's my role as her lawyer, not just do it the peaceful way. Some things just cannot be done that way, right? So back to being that person who has to go back to court and get the orders from the court, right? So this is how it is. Don't be once that person make the very, very brave decision to say, okay, I'm going to end this marriage. And for me, the next thing is please find the right experts to help you, because you have been in a cycle for so long. It's taken you so long to come out of it. It's not easy for you to suddenly say, no, I know exactly what I want. This is how I insist.
Exactly. Yeah.
You need people to help you get there.
And also from the perspective of a counselor, it's not like we just like, oh, sayang, and then we just attend and then we sit down and you cry and then we just, there are times where, when we notice that, okay, they are at a very stuck point. I have no qualms in saying, you know what, you need to talk to a lawyer. You need to find out what your rights are. And I'm not the right person to talk to at this point. You need to go and talk to a lawyer and then, go to talk to them about it, have the information, and then let's kind of process how that is like for you. Yeah.
By the way, back to the question about whether 3 or 4 months is too short. Well, by the time you do the divorce by mutual agreement, if the court thinks that you can reconcile, guess what? Back to reconciliation, no divorce.
Yeah,
that's true.
So don't lose hope.
I think that the courts do view marriage very seriously. So it's really about like, hey, what have you done right? To do your best in reconciliating, and is this marriage really broken down to the point that it, is irretrievable?
Yeah.
Yeah.
Yeah. Okay, on that note, I think it's the perfect time to bring our Q&A session to a close. Reminder to participants, remember to download the useful resources that I talked about earlier. Use the copy and paste on your browser or click the link that you see in the chat. We hope you found this webinar today, Divorce and You, useful. When the webinar ends, you will receive a survey on your browser, and we really appreciate your feedback because it will help us to make future webinars more relevant to you. Thank you so much, Susan and Abigail. I thought we had a great session today. Thank you for your valuable insights.
Thank you, Leanne.
Pleasure is mine.
Yeah.
Thank you, Leanne. Thank you, Abigail.
Yeah, thank you both. And thank all of you for staying with us. And so on behalf of Law Society Pro Bono Services, goodbye.